Good afternoon, welcome to the Glasgow Forum for Scots Law. We're very pleased to have with us Dan Carr from the University of Edinburgh, who's going to be speaking about will substitutes. I had the opportunity to read this paper actually during the summer because it features in this book, Passing Wealth on Death. And it's a comparative study into will substitutes, and Dan has given a brilliant contribution about how the law in Scotland might respond to this question of will substitutes. So we're very pleased to have you here, Dan, and without further ado I'll hand you over.
Well, thank you very much. Thank you very much for these kind words, and thank you for the plug for the book. I'm sure the editors will be delighted. I'm delighted as well, so thank you. And thanks very much for having me along today. Very happy to be here and to talk about the law of will substitutes in Scotland. I think, as Stephen mentioned, most of the substance of what we're seeing is in print in that chapter. So I'm not going to go through all of it in great detail, but I'm going to try and tease out what I think are some of the bigger issues and some of the uncertainties that exist in the law. I think the uncertainties are there for a couple of reasons, some of which are explained by lack of usage, and some of them are explained by more difficult problems in relation to legal rules. So I'll try and touch upon both of those as I go. So I think maybe the first thing that would be useful to talk about is what are will substitutes, because it isn't necessarily a term that rolls off the tongue for everyone, and it's really not that familiar a concept beyond the United States historically. Hopefully with that book and other things there'll be a greater penetration into other areas. Now of course there are occasional references to it. In fact, Ross's book on succession does in fact have a chapter on will substitutes, which is pretty forward thinking because you don't see many UK books dealing with law of succession which describe things as such. So what is a will substitute? Well, a will substitute is something that transfers or otherwise organises the transfer of some kind of property outside of the normal laws of succession. Now, immediately that's pretty difficult to nail down as an organising concept. Part of the reason is what one person's law of succession is differs. And so someone might say, well, actually, these are not outside of the law of succession, they're just another part of the law of succession. I would completely accept that. But all of them have in common the fact that they don't utilise a testament. So they're instruments that operate beyond the law of testaments or wills, as we have in Scotland. Some of them are more closely associated with what would happen upon death than others, and I'm going to go through a few different examples, and hopefully that will come out a bit more clearly as well. I mentioned a moment ago that the sort of original context for these was America. Just a tiny bit of history, because this explains a little bit of how they have developed as a conceptual category. The idea of a will substitute really starts to come out of American solicitors or American practitioners' practice in the 1940s and 50s, and then the academic rationalizations started to come through in the 50s and 60s. There's a few different reasons why the Americans appear to have decided they wanted to adopt these will substitutes. Now, as I just mentioned, the will substitute is something that operates outside of the law of testaments, or the normal, if you like, law of succession. So that rather suggests, and that is the American story, that the will substitutes are developed because of some dissatisfaction with the normal law of succession and the law of testaments in America, or wills in America. Particular problem seems to be felt with the law of probate. It seems to have been extremely expensive and or administratively burdensome. So people were not very happy with it. There's also a slightly deeper, almost ideological question about whether the American spirit is more inclined to avoid the state and probate, and these will substitutes often allow people to avoid the probate process. And so that gives another bit of context why in America you have this idea that maybe the probate system is not very efficient, the people are more inclined to avoid entanglements with the state anyway, and also this idea, there's another idea with some of the will substitutes, you manage to keep privacy better than probate, because probate traditionally is a public process, and details about your estate and what you want done with it will emerge. So that's sort of, if you like, the beginnings of the categorization which comes through in America. Now, you might be thinking, well, that's all very interesting, but why are you talking about that now? Well, one of the reasons I mention it is because the Americans have been doing this for about 50 or 60 years, they've reached the stage where a lot of their rules of succession law generally are refined and targeted at will substitutes as well. So they've sort of got to the second generation stage of, or third generation stage of will substitutes, in that their rules on implied revocation, the unworthy heir, things like that, are clearly applicable to will substitutes in the same way as they are to testaments. Now, because, as I'm going to suggest, Scots law has traditionally not really gone in for will substitutes under this organised category, we're not there yet, and I have no clear idea whether we should be looking into that. I think my concern here really is more just about highlighting what other jurisdictions have done in terms of will substitutes, and some things that we use in a sort of almost undeliberate way as will substitutes, but not as part of that more general category. So one thing that also will help just to frame the discussion, I think, is the policy goals that these people are trying to achieve by using the will substitutes. I mentioned they're trying to avoid probate, and they're trying to avoid the state, perhaps. There's also other things. They're trying to maintain, the thing you have to do when you're doing one of these will substitutes is you are trying to maintain as much control as you can as the settler, truster, testator, person dying, whatever you want to call them. You're trying to maintain as much control normally as you can, but normally the more control you have, the more difficult it is to have your will substitute do some of the things you want to do. And of course, another thing about the control part is traditionally a testament is ambulatory. I'm never quite sure if I pronounced that correctly, but it can be changed whenever you like until you die. We'll leave aside contracts of succession for the moment. Generally speaking, testaments, you can change them however you like. And some will substitutes are trying to get as close to that as possible while doing slightly different things, but not all of them manage that. Another big thing in American literature is the idea of efficiency. This idea that most, or at least many will substitutes, will operate in such a way that the will substitute will carry the property of the goods directly to the estate of the person you have nominated or identified, and therefore completely bypass what in America is the probate process, and in Scotland is the executory process. So you go round the executor and confirmation. So that's an efficiency argument that's often mounted as well. I think one thing to say about that, and I should have prefaced the entire discussion about this, is I am not a tax lawyer. And so I'm not going to say anything really about tax law, because I don't know a great deal about tax law. My understanding is that most of the will substitutes in Scots law would not be particularly useful for evading tax. Might be useful for evading other creditors, perhaps, but not tax. But I don't know enough about it to talk with authority, so I should say that initially. Another thing that will substitutes often try to do is get around the formalities and adjectival law, which is associated with testaments in most jurisdictions. Now, I don't think that's that much of an issue in Scots law, because the requirements for a valid will in Scotland are so, the bar is very low, it's not very hard to have a valid testament, so I don't think that's a massive concern for a Scots lawyer who might be thinking about doing a will substitute. But then, at the same time, it still has to be in writing, and arguably some of these will substitutes don't, and that's slightly controversial. We'll come back to that as well. And the final thing I mentioned just in passing there was the creditors just there, this idea that you're often trying to evade creditors. The executor, when they gather in the estate, will be responsible for paying off any debts. Of course, in order to pay off debts owed by the estate, there has to be, the asset has to be in the confirmed estate to pay off those debts. So if you have a will substitute that stops it going into the estate, then it will not be used to satisfy your creditors. So the theory goes. As I say, the tax law is a little bit different there, but normal creditors will be, you can arguably evade normal creditors as well. Okay, so those are some of the policy objectives that people are trying to obtain when they're using these will substitutes. I'm going to go through a few different types of will substitute as I identify them in the paper. I should say that the paper, you might read the paper and think, well, if you're going to read the paper at all, which of course one is under no obligation to do, but if you run out of here and read the paper, you might think there's a couple of big holes in it. Probably the biggest hole is the trust. The trust does not appear. Now that was because the paper was written for a comparative piece, and I was told don't bother with the trust because we're getting plenty of trust stuff from the other common law jurisdictions, so we don't need to hear any trust stuff from Scotland. It's just to say that the trust is, of course, a very effective will substitute in some situations. I'll say this. I actually was having a quick chat with Stephen about this earlier. In the US, the trust that's normally used as a will substitute is the revocable trust. Now, in Scots law, from what I can tell, we have revocable trusts, but they don't have quite the same magic that the American revocable trust has, because the revocable trust, as it exists in Scots law, and I think it does, they certainly talk about it, is unwound at the behest of the truster. So if you create a trust which is revocable, you can unwind it. So that doesn't generally, so the theory goes, protect you very well against creditors, because creditors step into your shoe and they just unwind the trust. That's fine. In some American jurisdictions, your right to unwind the trust is considered to be so personal that it is not an asset which the creditors can attach and unwind the trust. So that, yes, sharp intake of breath. So that is why, not in all states, but in some states, so that's why the revocable trust is talked about so much in America. It took me a while to get a handle on this. Well, what's so exciting about this revocable trust? If I'm a creditor, I'll just unwind it, and that's that. But there seems to be some more complications in America. So that's a long way of saying I'm not going to talk very much about the trust today, but the trust is probably the elephant in the room. We could talk about that at some length. So some other sort of types of will substitutes that you might see, or at least could be running. I think that's the issue. I think one of the themes that's going to come out from what I'm going to say is that most of these, as with much of Scots law, most of these concepts, there's a fair amount of flesh on the bones in the 19th century. There's quite a lot of people, there were a lot of rich people in the 19th century trying to avoid their creditors and trying to make sure things got to their kids in the same way as high net worth individuals nowadays try to do similar things. So the cases are actually fairly rich, I think, but then they don't really get used to develop the idea of a will substitute after the 19th century. So I think what I'm saying is a lot of these things, there's a decent amount of case law you could work with if you were inclined to try. And the overall conclusion of my piece was that there's quite a lot of scope here for some, I think I described it as juristic entrepreneurialism among practitioners and academics. Of course, I completely understand if you're a practitioner, you might not want to just have a little jolly and try all these different things with your client's money. I'm entirely aware of the fact that that might not be that useful, but I'm just going to say that I think there's some things that could be tested or at least gone into in a bit more detail. Okay, enough throat clearing. Joint accounts. So the first possibility for a will substitute would be a joint bank account. Now, these are fairly commonly described as will substitutes in other jurisdictions. In Scots law, there don't appear to be any cases recognising an effective bank account that would operate as a will substitute, in that two people have a bank account, one person dies, the other person gets everything in the bank account at the cost of the other person. Now, from what I can see, I haven't seen any cases that say that's fine. What the cases tend to say is the joint bank account status is merely administrative. So each person has a right to the other half, as it were, of the bank account. So while when the joint bank account holder dies, the sole remaining holder has the sole right of administration, the person who's died, their interest is still there, and that goes into their estate. And that seems to be the way that most of the cases have gone. But there's really a distinction to be made between, and the cases say the distinctions between, I can't remember if they actually use the word ministerial, but I'll use the word ministerial, and the substantive right. So there's the difference between who gets to administer the account and who actually has the right to the funds which are in the account. Bank accounts, of course, being a debt. But you could apply a number of different instruments to what's in the bank account, or what the bank account is. And there were, from what I can tell, quite a few attempts in the 19th century to try a special destination in relation to bank accounts, particularly deposit receipts. Now, they're rebuffed repeatedly. For bank accounts, deposit receipts are normally turned down as a special destination. There are hints that you could try a donatio mortis causa, but since the 2016 Act, that's going to be very difficult. So I don't really want to say too much more about that just now. You could arguably have a third-party contractual right out of one of these bank accounts as well, and there is a case that suggests that might be possible. So you have a jus quidem tertio, which comes out of the bank account, so you bestow the interest on someone else, and in that way you avoid the estate. But none of this is clearly tested, from what I can tell. So the joint bank account is a possibility, and I'm going to come back to special destinations and joint or common property right now, because common property is another possible will substitute. One we say is very controversial. I'm not sure I agree with the orthodoxy about common and joint property in Scotland. So in Scots law, there's commonly said to be common property and there's joint property. So common property, everyone has a pro indiviso share which is identifiably theirs, and that's theirs. You can't necessarily see it on the joint property, but they have a fixed share. Whereas joint property, trusts, unincorporated associations, the best known examples, which is deliberate wording, are different, where you have everyone has an interest, and as people come and go, their interest accreases to the others. Now, the potential to use that as a will substitute type mechanism, I think, is fairly clear. It does happen in other jurisdictions. They talk about it as another way of using a will substitute. In America, they talk about joint tenancy, and it's the same as our joint property. Now, the leading case, as subsequently interpreted, has been, I think, and I'm very happy to admit, the vast majority of people say that you can only have joint property for trusts and for unincorporated associations. And then all other types of common property are common property. Now, my reading of the case, the Banff and Ruthin Council case, is not actually that absolutely clear that the court said you could never have any other joint property interest. And I think Lord Cooper arguably leaves it open. On the other hand, I am willing to concede that that is a pretty out there view. I'm not sure how many other people would buy it, and I'm not sure how many people would want to test it and say, we are holding this as joint owners, and therefore we are having this joint property, not as common property, but as joint property, so that when one of us dies, the share of the other automatically is reabsorbed, if you like, by the other's share. Now, that is how a joint tenancy works in England. the Scottish case law, as I say, as interpreted since the case in Banff, seems to suggest that that would not be available by choice. You couldn't choose to have that type of common property. I'm not sure, but I'm pretty sure I'm in the minority there. Of course, Scots law does, instead of the joint tenancy, have the special destination, which does a lot of the work of the joint tenancy, which was done in English law. So special destination is, certainly, it's interesting, at this conference, this was the thing that most people were most interested in, because it wasn't something they easily could identify as something they had in their jurisdiction. Because everyone said, oh, it's a joint tenancy. Well, it's not quite a joint tenancy, because all of our cases say they're not about joint property. And they're certainly conceptualized in a slightly different way. So special destination is where you have an inherent condition attached to an ownership interest. And they are not testamentary writings, which is something that is fairly important. We'll come back to a bit later. So special destinations, you carry the interest of one person to another by force of law. The most common one is the survivorship destination inserted into conveyances of heritable property in favour of two or more purchasing the property. Now, when the survivor dies, the survivor does not die. When the other person dies, the survivor takes their interest via the special destination, and an executor is not necessarily involved. Now, the law here has been changed a little bit around the edges in terms of the revocation rules fairly recently by statute. As I'm sure most people in this room will know, the special destination did not have a very good reputation. I suspect from the 1970s onwards, but maybe before that, for a couple of reasons. The main reason is not all that many people actually understood exactly what it was going to do, and also the bigger criticism was the fact that they were not automatically revoked upon divorce. And that was one of the sort of traps that caught a lot of people out, because survivorship destinations were normally, if they were taken out, would have been taken out by a husband and wife. Now, there's been statutory reform there, which has provided for sort of automatic revocation upon divorce of these special destinations, and that chimes with the law now in relation to legacies. But when I wrote this paper, they were not exactly aligned. So that was another thing to take into account. So special destinations are another will substitute. I don't propose to go into massive detail about evacuating special destinations and revoking them. One thing to say, though, is that while there are ways of getting around the special destination, the one slightly more challenging way of evacuating the special destination has traditionally been, what if one of the parties left it in their testament to someone else? How would that possibly evacuate the destination? And the rule, the most common rule here is the parents trustee rule from the 1909, which says that if both parties contributed the price, then you have the power to evacuate the special destination just by virtue of leaving it to someone else. And there is the case, the parents trustees case, could trap people, and especially if they are not yet divorced, even now with the statutory rule. Now, the parents trustee case has been criticised a lot, but has survived unscathed over the years, or certainly not particularly reversed. So in a later case, Shan's trustees, despite the fact it was described as a bastard child lacking precedent, principle and legitimacy, it was fine. And that was a decision of the full court, and they said that parents trustees fine. And actually, a very enterprising case very recently, Hill against Hill, in the Outer House, following the 2016 Act, where someone tried to attack parents trustee again and said, look, now we've got this de facto revocation upon divorce. That should be another means by which we can try and sort of have a go at pets trustees, and the court said no, pets trustees is good law, it's been confirmed by full court, and of course divorce statutory will kick in, but that you can't use that to then go beyond the statutory rule and suggest that actually this means that people should be allowed to evacuate in situations where divorce hasn't actually happened. So a will substitute of some interest, certainly beyond Scotland, is the special destination. I have been talking a lot about it because I mentioned it normally inserted in a disposition. We tend to talk about them in relation to heritable property. That's where you see them mentioned most often. My research suggests that you can have them in movable property quite happily. And there is some uncertainty about it, of course, but there seem to be quite a lot of cases that look like they have special destinations in movable property. Now, the special destinations that I was able to trace were in stock certificates, bonds, debenture bonds, documents creating an annuity, and certificates of debt. So they were apparently capable of sustaining a special destination, whereas the deposit receipt we mentioned earlier could not. And it seems to be that the basis, the overarching principle, is that you will be allowed to have a special destination in one of these things if the document itself forms the title. So if it's a document of title, then the sum contained in it will be susceptible to one of these special destinations. And you see that really in the 19th century case, leading case Connell's trustees. So I think what interested me really was the fact that it struck me that no one bothers even trying to do them, from what I can tell, in relation to anything other than land. And that might be because people don't like them and they're not very popular, but I don't see why necessarily they should be completely ruled out as something to use in the future. The other thing about them is they are not testamentary writings, and I mentioned earlier the idea of revocation and evacuation. They will not be taken out by a general revocation clause in a testament, which is of some significance. So you have, if you're going to try and get rid of one of these special destinations, you have to have the power, and then there's the formalities rules in the 1964 Act in section 31, I think. So special destinations are another quite interesting will substitute because they take place outside of the executory system. Another one I mentioned in my paper, which I'm not going to go into in great detail because I think it says for half an hour talking, is life assurance. Again, life assurance. I think how that might operate as a will substitute is probably fairly clear. You pay money into a life assurance policy on yourself, someone else who you have an interest in, and that can operate in a way that essentially keeps wealth somewhere else outside of the executory system and will be payable to someone you've identified. One of the reason I'm skipping over that is nominations are one of the things I want to talk about. Nominations in your employment contract or pension, commonly described as death in service. Our textbooks mention this. It's mentioned in Ross's book, in MacDonald. Curry on Confirmation of Executors talks about them as well. The statutory ones, there's certain statutory ones limited to nominations of up to £5,000, the so-called statutory nominations, and then there are the death in service nominations, which are not capped necessarily at £5,000. Now, these nominations are quite significant, and from what I can tell, the law here is very murky, and it's quite murky in relation to the law here is quite murky in England as well. What exactly is the status of one of these nominations? I think everyone's fairly clear that, well, my employment contract with the University of Edinburgh has a death in service provision, or rather the pension does, and I have nominated certain people who will not be watching, and they will receive their funds at some point. Now that will happen out with the executory process. Where this becomes slightly more problem, I don't think anyone has any major concerns about that per se. Where things become a bit more complex is how that payment, that nomination payment made to someone you've identified, interacts with other bits of the law of succession. That's where I think some of the murkiness comes in. Because there is mixed authority across the Commonwealth, actually, about whether these nominations ought to be considered to be testamentary writings, or whether they should be considered to be something akin to what in English law they call power of appointment. Now, there is Privy Council authority saying that it is from Trinidad and Tobago, saying that these would not be testamentary writing, and there is English case law which reached an opposite conclusion. Which reached a similar conclusion, but the Canadian cases seem to suggest that they would be testamentary writings. But the case law is very limited, like astoundingly limited on this point. Now, the reason why this might be significant is most revocation clauses in a testament will refer to testamentary writings. And if your revocation clause says, I'm abolishing everything I did in the past, does that catch your nomination in the pension? And that's the sort of crux of the issue. Now, there's one of the things that when we had the conference which led to that book, one of the things that people said to me after we exchanged papers was, oh my God, Scots law's got so many cases. It's the first time I've ever heard that about anything. You've got so many cases, and we have actually quite a lot of cases on nominations. Unfortunately, none of them say the same thing. There's a reason for that, I think, because they emphasise the wording of the nomination itself, which I can understand that, but it still makes things a little tricky. Some of the nominations were statutory, and some of them were drawn up by the particular terms of the pension fund. So there is difficulty here about how these nominations are revoked, especially because I've never tried to do anything with my pension, but I understand if you try, it takes some time for anything to happen. If you write to your pension company, we'd like to change the nomination, apparently it takes quite a long time. So I think the potential to revoke is intriguing. Scots law, I don't think, I mentioned to you at the beginning the formalities issue. I don't think the formalities issue is so much of a problem for Scots law because our formalities are so basic for a valid will. But in other jurisdictions, this is an issue because you can have a nomination which is pretty informal, which would carry things in a way that a testament wouldn't. The other thing about the nomination is, of course, creditors' rights. And if it's some nominations say pay to the executor, which will be susceptible to the creditors of the deceased. Some say pay direct to the person you nominated, and it seems that those nominations will not be susceptible to the debts of the deceased. There's case law that suggests that, which is arguably a bit problematic. There's also a question about whether or not it would be covered by legal rights, which is something else we will no doubt talk about later. The last thing, I'm conscious I'm already over time, so I'll try and be quick with the last part, is the idea of succession obligations. Succession obligations. Now, these are quite slippery concepts. I've deliberately used the word obligation because quite often they refer to succession contracts, but there might not always be a contract. There might be some other obligation which is binding upon the soon-to-be or deceased person. Now, there's really two types, or many types, but two important types that with the distinction I would like to draw is between one of these obligations which actually provides for the distribution of property, and another obligation which tells we'll call him the deceased, what to do in their testament, or what they should be doing in their testament. And they're slightly different. Now, most jurisdictions, including Scotland, from what I can tell, are not big fans of the contract which actually distributes the property and just doesn't allow them. But they do accept the fact that you can undertake an onerous obligation that you will leave property to the certain people in certain ways. And these contracts are valid in Scotland, according to Stair, no less, and they're also valid in Australia and in England. Now, if you got one of these, I'll call them succession obligations. If you've got one of these succession obligations, then things, I think, get quite complicated quite quickly, because you could have positive or negative obligations under that will substitute. Now, it's not will substitute in the sense it's completely taking the place of the will, but it's doing quite a lot of work in the area of the succession. So you could have something that says you must leave the following things to the following people. You could arguably have one that says you must not leave the following things to the following people. I suspect the latter might be more open to general public policy attack, as it were, but it's hard to say without more detail. The other thing that might be asked is that there could be a contract or some kind of other obligation that this would really be a contract actually, saying the person has to revoke their existing testament. So I'll give you £10,000 if you tear up your will. Now, all these things arguably are binding obligations which would affect either succession or the means to succession. Now, there are many, many nuances and interesting things to say about this, I think. What I'll concentrate on is, the first thing to say is the formalities point. These obligations, the constitution of these obligations will be possible in a manner that is noticeably less formal than a testament. So you could conclude one of these verbally obligation requiring you do certain things in your testament. Because most of the cases about this are 19th century cases, they were all proceeding on totally different bases of how you proved an obligation. It's not based on the 1995 Act, so all of this has to be taken with a gallon of salt. But I think there's certainly scope for some difficulties in relation to these succession obligations. And if we are, as I think we do, saying that these are enforceable, how exactly are they enforced? Can you have specific implement? Yeah. Rewrite your will. The court is not, I think, going to force someone to rewrite their will. I could be wrong, I don't know. Or if there's one that says you won't rewrite your will, so you get an interdict against your will. And if you have a system where all is ambulatory until you are dead, but yet you can engage in an obligation which stops you doing any of this, that's, I think, difficult. And there doesn't seem to be much in the way of strong policy guides about this in the courts. And as I say, most of the cases are based on quite out-of-date modes of proof, and as far as I understand it. So I think some of these are quite pressing difficulties if people were to start engaging in this. Now, of course, these don't seem to happen all that often, although I'll come back to that in a minute. But if they were to start happening a lot, I suspect the courts would probably lean on various rules of whether it's public policy or proof. What seems to have happened in the cases that I've been talking about, the ones that came around before the 1995 Act, most of them seem to say, of course, this is absolutely possible, but here it is not going to happen because this has not been proven. And so the courts seem to be quite happy to say in the abstract this was a possibility, but when faced with it, it was too galling to use. Another problem with these is the slightly odd ranking system when it comes to test date succession. There's a lot more to be said about remedies, but I'll leave that just now. The question of if you enter into one of these obligations, or I'll call it a contract, and there's authority, old authority that says you've entered one of these contracts and then you write a will in breach of it. There's authority that says that that is void, the will afterwards. Now that strikes me as quite hard to get your head around. Now, I don't think they mean void. I don't think they mean void. But the authorities could be read in that way. So you have one slightly curious suggestion that by entering into a succession contract, a testator makes his will irrevocable and unalterable. So says some case law and some of the institutional writers. But what exactly that means is not clear. Whether you could just drop your will in defiance of the obligation and then you just take the hit in terms of damages or potential specific implement or interdict later, who knows? Or whether the original will is put in aspic and that's it. Now, I don't think that can be right, but I think the authorities are not very clear on that. The other thing is offside goals. There's a recent case about this, a recent case called Wheeldon's Executor against Spence's Executor in 2014. And this seemed to allow relying on the offside goals rule in relation to an existing contract of succession. So the idea was that there had been a contract entered into in relation to the property, and then the person breached that contract and left it to someone else in the testament. And because the offside goals rule attacks people who are either in bad faith or gratuitous transfers, that opens up a lot of testamentary transfers, because most of those are gratuitous. So the offside goals rule was used in the Wheeldon case, which rather suggests that it's voidable as opposed to void if you breach one of these succession contracts. But I'm not sure how well thought out any of this is. And the final thing I want to just sow in your minds is the idea of legal rights and our ranking system. So the cases say that you are an heir among creditor and a creditor among heirs. So if you are the legal rights, you're entitled to your legitim. You're postponed to the debts of the estate, but you come in before the legatees. Now, if you're allowing these succession contracts pre-death, one can say, well, they are arduous debts upon the estate, and they will take precedence over the legal rights holders. Now, that is problematic, I think, because it means you're getting around legal rights by using something that isn't. If you have a system that says testaments do not affect legal rights, these are forced heirship rights, but if you have a contract before, knock yourself out. Now, maybe I've missed something. I really hope I haven't. But that seems to be that's the logical final step if you accept these succession contracts and say that they are enforceable. That seems to be where you get to, and I think that is quite difficult. Now, it might be the courts would just cut them down to it's contrary to public policy or something like that, but there's no clear steer on it from what I can see. And because we don't really get that many cases about legal rights, it's quite hard to know. So, that's the last thing I really wanted to mention about the succession obligations. I think the authorities here are open to some question, and there could be, well, it depends on who you are. This could be terrible or this could be magnificent. It depends on your view of the law and what you want to get out of it. And I think that my conclusion, more generally about will substitutes in Scotland, is I think there's quite a lot of scope to try things. I think there's quite a lot of avenues that are not sealed off. One of the things about our legal rights is that they are curiously toothless compared to most legal rights regimes around the world. There's no real clawback provisions at all. So getting around them isn't that tricky anyway, and maybe that's why, well, if you just give everything away the day before you die, who cares about a succession contract? And maybe that's ultimately where you come to. But then maybe we should just get rid of legal rights. But where's the mute button? That's a whole different question.
Not go there.
Yeah, that's a whole other question. So I think the Scots law is interesting because there's quite a lot of material there that could be used to come up with quite creative, non-testamentary mechanisms or institutions that could affect things after the death of someone. It's just that for some reason, we don't see them used very often. Now, it might be I'm not in practice. Maybe they are used a lot in practice, and I just don't know about it. But you don't tend to see them in the courts very often. And there could be any number of reasons for this. It might be that people are fine with the law of succession. They don't want any will substitutes because it's all running along fine and everything's efficient and the commissary process is fine and that's all fine. That could be it. Maybe there's just no interest in it. Because the American will substitute revolution was a popular revolution. There was a book written by the 1960s book. What's his name? Yes, by Dacey, with an exclamation mark. How to Avoid Probate, and it was really popular, like bestseller lists, and sort of heralded this big revolution. And there seems to be absolutely no interest in it in Scots law. Whether that's because the case is still to be made, it's interesting. Final thing to say is it's not only America that has these other instruments that they use. New Zealand is fascinating. Everyone and their mother has a trust in New Zealand, from what I can tell, which is really interesting. And they're not only used as will substitutes, but the prevalence of trusts in New Zealand is absolutely mad. And so I think what I'm saying is Scots law could develop lots of new interesting things, possibly using the existing law or developing and refining the existing law. And so there's scope for judicial entrepreneurialism, I'd say. I'll leave it there.
Okay, thank you very much, Dan. Would people like to ask a question?
Yeah, can I
please do.
I've got first year
Please.
Yeah, just ask one thing, well, two things. Interesting about avoiding probate because I think it was either the most recent Philip Hammond budget or the one before that. England has just introduced huge probate fees.
It was on the radio today.
Yeah. Up to, I think the maximum is £20,000.
Right.
For very high value, so it's a scale. There's nothing at the bottom end, but really significant probate fees for large estates. So I wonder whether they'll actually, there might be some incentive to avoid probate.
Well, absolutely. I mean, it's interesting you say that because I actually heard that just as I was coming in the house earlier on I think it must be the Trail for Money box on Radio 4. I've outed myself. Yeah. And they said but that's one of the really interesting things because you had this the way they framed it I thought was really interesting because they said when is a fee a tax and when is a tax a fee? Yeah, of course. But of course the difficulty they will have here is actually ties right in with what I was just saying. I think most of these wouldn't escape the tax man, but they would escape the fee man. And that would, as you say, would be quite a significant consideration, I suspect, in some cases.
And the only other thing that I was going to say was it's maybe not of as much relevance in Scotland because we have such low confirmation figures. You're talking somewhere between over 50% of deaths are not confirmed.
Right, okay.
So I think there's a whole lot of just informal distribution going on, preaching all sorts of things.
I didn't know that.
I think there's a kind of consciousness in Scotland. I think people think the law shouldn't be involved with this stuff. We'll just decide. And it's probably only if it's contentious or large, or there's a lawyer involved.
So I mean, it's the ultimate will substitute.
It's
a law substitute. Yes, exactly. Yeah.
I would say most banks up to £25,000 usually they'll just discharge.
Right, they'll just do it.
Without confirmation.
That's really interesting. Thank you. That's really interesting. So.
Thanks, Dan.
No. Cheers, Tom. It's good to see you.
I remember the special destination point doing a paper for a banking client, and it was all about reviewing their terms and conditions.
Right.
And it was an English case, and it was all about whether the terms and conditions you signed up to a contract that it was held joint and the survivor. so that you were contractually binding yourself to make a gift to the survivor.
Interesting. So that's exactly it. Yeah. And that was for a Scottish.
That was actually an English client and
Right.
bank, but I think we have reviewed terms and conditions for Scottish clients as well.
And this sort of thing is happening then. Okay, that's really interesting.
Whether or not customers are aware of what
Sure.
they're signing up to, and whether or not actually in practice it's enforced,
Sure.
or you still.
What were they signing up to? What was
The
it?
terms and conditions in their banking contract stated that on death the bank account funds were automatically transferred to the survivor. So it was a kind of, I think it was rebutting the presumption against gift.
That's really interesting.
And I can't remember which way around because I've not looked at this for ages, but I think in Scotland there's maybe a presumption against gift, whereas in England there's a presumption in favour.
Yeah. That's really interesting. Thank you.
But as I say, in practice quite often, you don't even need to ask.
Yeah.
You just send your normal inquiry letter asking what the date of death balance was, and actually you get the funds back.
That's really interesting. And do you have to send like a death certificate or anything?
You normally send a death certificate verification form.
And then that's it?
And sometimes they will ask the executor to sign a kind of, they're giving up their liability.
Sure. Yeah.
They undertake to pay to the correct beneficiaries, etc., etc. But
That's really
as I
interesting.
say, sometimes the banks will just send you the bank account proceeds
Wow.
information.
The terms and conditions to would not necessarily change the law of the underlying ownership. That would be technically a separate thing.
Yes, because we take the view that we would still include it in a confirmation unless the executors kind of give us free rein to check the terms and conditions and try and get away, without confirmation. I think we would just do it and give the executors confidence that they have obtained proper title to that asset.
Sure. Because the other thing is, in the vast majority of these estates, it's not going to be huge amounts of money either. So.
And I think because of the compensation rules, where it's £85,000, a lot of clients did spread their funds over to their bank accounts, so we are finding quite often we don't have large amounts in one bank account, the clients have spread them.
That's really interesting, thank you. One thing that's made me remember is, of course there'll be banking practice, which would be really interesting for me to look at, and the pensions practice as well. It sounds similar to what you were just saying about, like in the terms and conditions and the nominations. A lot of the cases, so my paper is not the only paper in that book. There are also other excellent papers in there, and the paper on England is really interesting because by Alexandra Brown, she went through the pension ombudsman case law, and the pensions ombudsman has developed some kind of cases or some kind of jurisprudence about it, and who should get what. But it seems to be a sort of separate entity of law that's going on.
For again, pension nominations, we would normally treat those as more just akin to like a letter of wishes.
Right.
Quite often you must state in a pension nomination form that it's absolutely not binding
Right.
on the trustees.
Yeah, that's right. Because that's right.
It has to meet that criteria for the pension scheme trustees to have the necessary discretion
To invest in
for the tax rules.
Yeah.
So most pension schemes are set up where it's held by a discretionary trust, and obviously can't better the discretion of those trustees.
No.
So any nomination form has to be framed in such terms that these are your wishes, but in no way is it binding. Bear in mind that I've set up a family trust, or bear in mind that I wish my
Sure.
wife to receive a third or whatever.
Of course, yeah. Yeah, then because it's
So we kind of look to trust law more than succession law, I think, for a pension.
Yeah. Which would make sense. I'm just trying to think. I'm more thinking about in America, if they would have a lot of what I wrote was based on the sort of secondary rules they've developed, and this idea that you can have this revocation clause. Would your testament affect a letter of wishes? Certainly not.
I mean, we would revoke a previous will without second thought.
Yeah, indeed. Yeah.
Affecting the pension nomination form.
Yeah.
Because that's open till the very last minute.
Yeah.
It's an expression of nothing else but your wish at that particular time.
Absolutely.
I mean, certainly when we're drafting new wills for a client, we always say you must update all these nomination
Yes,
forms
absolutely.
at the same time because it's as important, if not more important,
Sure.
to get your pension stuff.
Sure. That's very interesting. So thank you very much.
Any other questions?
Can I? Oh, we're only,
Ross and John.
Can I maybe hang a observation, thought, see what you think
Please.
on special destinations?
Yes.
Because I've spent a blood curdling week trying to get my head around them,
Right.
or completely coincidentally, and particularly using Perrott perhaps as a peg to hang it on, which obviously is seen as the mainspring of modern law.
Sure.
Perrott strikes me, that whole development strikes me as a fairly bizarre one, because it's almost a very un-Perrottian sort of case itself. I mean, I think they said in one of the later cases, you never really use that case as a precedent.
Yes.
It's not, there's no great even deep legal reasoning in the judgments as far as I can see. They just suddenly, you just get the statement by, forget who the judge was, doesn't matter, one of them, he just comes out with this, well, contractual, this, that and the other, and the later cases have just followed it.
Sure.
It's not obviously where it comes from, and I can only assume they've got the sort of dimly remembered stuff, which I suspect comes out of marriage contracts.
Yes.
The contract where it was fairly deeply rooted, that you couldn't, if you got a, which is nothing to do with survivorship destinations as such, as far as I can see, but if you had a marriage contract settling the distribution, then you had a long built-up jurisprudence as to who was going to be protected from that.
Yes.
And I think they're building on that. And then they make that decision without much thought, and then they suddenly realise, later, that they've actually done more than real. And then you have this, much later when the steel gets cold, the lifetime gift will get round that. And then I think maybe you, certainly George Gresham, pointed out, well, actually, the earlier distinction was rather more between gratuitous deeds and onerous deeds, not just the fact that lifetime or death wasn't the categorization. So they ended up really, I think, without much proper reason they've gone along. And I'm wondering, various reasons. One, lack of good judicial reasoning on the bench. Two, relative lack of case law compared to, say, England and the like. And thirdly, but not exactly maybe just a general law precedent, but there's this feeling, which I've been looking at House of Lords case law more generally, that, well, if it's dealing with title deeds, then once the precedent is there, you don't want to change it, however bad it is, and you get stuck with it, and the legislature are going to have to sort it out. So either way, I think partly because we're a small jurisdiction, you end up with that sort of mess.
Sure. I mean, I agree with you. I mean, one of the things I think I hint at it, I don't put it as clearly as you did there, but hint at it is the fact that the rule in Perrott is one among many about when there won't be the power. And as you say, it's normally where there's some kind of arduous contractual obligations being created. And the one sort of key example that in the past would have been the marriage contract. And actually, quite a lot of the cases I cite are actually about marriage contracts. When I'm looking at the succession obligations, I call them, a lot of those have come out of marriage contracts, which are not to be seen nowadays.
I think you imply, well, you have I don't know, a fairly sudden drop-off, but the whole regime of matrimonial property changes, and once you have separate matrimonial property, there's no need for all these
protections and
competitive regimes and clause of return. So the law sort of like sticks like a stagnant glacier, doesn't move on. And so we're stuck with 19th, early 20th century case law, and it's not really living law at all.
Well, I think that there's a lot to be said about that. One of the things, I mean, I say that, I mean, Perrott, as you say, is there. I don't know off the top of my head the details of what they say in the full bench case when they review it. I can't remember if they say, look, it's just precedent and that's that, or if they come up with slightly more exotic justificatory.
The precedent one is
more
general thing. I can't remember.
Sure.
Certainly, I've been reading on
the later ones.
Where they take that line, it's conveyancing, title deeds, and therefore
I mean, it's curious it's not been uprooted, though, by statute, when they sorted out some of the other bits.
It just proves how unsexy succession is as a subject for the... Anyway, look how long it took for the thing about the divorce stuff. I mean, it only came in by the back door with the Family Law Act 2006 or something. It started because people realised there was a problem and the whole law reform community couldn't get that together, so was it private members edition or something, and they built on that. But you know, there's no coherence to the law reform.
But I mean, I think it's interesting what you're saying about the development of the law has not necessarily been particularly reasoned. I definitely agree with that. It's interesting what you're saying about this. Everything you say about the broader context, if you like, of the families and the family law and the way in which people were managing assets and wealth makes sense to me. And the fact that some bits have been changed or taken out of that scaffolding, if you like, probably hasn't been fully worked out. I think that's definitely right. What happens next, I'm not so sure. I'm not in any way a family lawyer. I don't even know if marriage contracts are still competent. Are they still competent? I don't know. I don't think.
I've never heard that they weren't, but maybe I just hadn't heard of you.
You just don't. But I think they are still competent.
Yeah, because you never see one. Because I had this conversation yesterday with someone, and I said I'm pretty sure that they're not abolished, but you just would never see one.
Yeah, when it was a big issue in the Rads or whatever case in England, you know, whether you could have a binding, because you couldn't have a binding marriage contract there to decide what's going to happen in a divorce, and then you had the Supreme Court case a couple of years ago now. And I have a vague idea of its comments up here was, well, you know, it's not really an issue up here in terms of, it's not, or people would certainly have said, well, it's illegal here as well. I think just Scotland is off the radar.
I think like if it's a sort of anti-nuptial contract like that, then you can have it, but the court can strike it down if they think it's unreasonable. So I think like a lot of...
Why would you bother?
Like, what's the point? Because the sort of situation in which you would want to have it is one where you're trying to control that in a way that the court is not going to allow you to do, because that is precisely the situation in which it would no longer be fair and reasonable to have that contract. So I think maybe just the legislative control, it's been legislatively controlled out of having any function.
Which would make absolute sense. I guess which prompts me to wonder whether there should be some similar power in the court on death. So if something is ended on death rather than by divorce, you should have some overarching power in the court. How you draft that, I don't know. But
yeah, I guess the thing is that, well, to my mind at least, divorce heirship rules are the equivalent of the divorce rules for death, because they're what happens when you've been bad, or when you're trying to be bad to your spouse at the end of the marriage relationship. I mean, from that point of view, it's perhaps quite attractive. We just apply the divorce rules of death and then we wouldn't need divorce.
Well,
the irony in a way is, in a sense, we used to, before 1964, you had the regime on death, wasn't it? It was, I mean, it was maybe a very sex-biased thing, but there was a logic to it, and then divorce went its own way, and succession didn't really go any further.
That's sort of the point I was... Because think about the cohabitant. I mean, the cohabitant relationship ends in life, and then there's a cohabitant relationship ends through death. Now, they're not exactly the same, but there's quite a lot of overlap in terms of even just the regime and thinking about it. And you could argue that maybe there should be something like that. If divorce is...
Although, to be fair, it's not clear if there is a lot of overlap between those two things on the basis of the fact that nobody knows what they have.
Well, that's true, okay. If we take the courts kind of at face value in Oberton, they're not kind of saying, oh well, they're useful a little bit to help. Although, as you say, if you have two things you don't know anything about, you can't really use them.
I think you can make an argument about what the regime on separation is supposed to be doing based on interjecting from the court, but there's no evidence on what the regime on death is.
No, indeed. Yes.
The cohabitants were still at the arbitrary stage. It was section whatever, 29, whatever the one. Gives absolutely no guidance to the courts whatsoever on death.
But they've kind of said, well, we might look at section 28 a bit. I mean, not very. I mean, I'm not saying it's, oh well, it's all fine.
Still making it up as they go along.
Yeah.
Johnny, you?
Yeah, this takes us down a completely different route. So if we have more to say on sort of family stuff, maybe that should be said now rather than. When you were saying that people use this as a way of basically avoiding creditors, why not just strike them down as fraudulent transactions?
Well, like all of them.
Yeah, I mean, if they've been done in express contemplation of defeating creditors' hopes of satisfaction, then right back to the beginning of your life, they're voidable under the Acta Pauliana.
Okay, well, if that is the case, I didn't know that you could have fraudulent. So if it's, well, it depends what you mean by okay, right, okay. Depends what you mean by fraudulent avoiding creditors.
Yes.
Because you could say there's three categories of creditor. There's current creditors to whom you already owe debt.
Yes.
Now, if you're trying to get away from them, that's probably fraud.
Absolutely.
You've got likely to turn up one-day creditors, so sort of almost in contemplation ahead creditor. So, like your kids, they're going to be creditors of some description, but through legal right at some point. So, arguably, putting something away from them is maybe it's still fraudulent, maybe it's not.
I mean, that is fraudulent in the sense of fraudulent trading under the Insolvency Act 1986, for instance.
So if you know you will owe someone something at some point,
if you know that you're going to, fraudulent trading is kind of the other way around. If you carry on trading and taking on new debts when you know that your estate at the end, or the company's estate at the end, is going to be insufficient,
sure,
then taking on those debts is fraud.
Does that apply to individuals?
Yeah, I mean, there's case law about sale, the sort of tantum cases, which basically say that if somebody concludes a contract of sale, knowing themselves to be insolvent and unable to.
Okay, but in that sense, you've got a fairly good idea of the creditor and how much you're exposed by. I'm more thinking. So say I'm setting up. We'll use a trust, for example.
Yeah.
Let's use a trust. So I decide to set up a trust, and I think, right, God, I hate my kids. So I don't want them turning up in 25 years wanting stuff.
Yeah.
So if I put property into that trust, I wouldn't say that was fraudulent.
But I suppose there are two things. One, to a certain extent, where there's a trust, if the trust is legitimate, you're seeing the aim of the transaction is not to defeat the creditors, but to pursue the trust purposes. Any insolvency effect is ancillary to that, and that's the whole justification
for the trust. Sure.
Secondly, with respect to your children, the extent of their claim depends on the content of your estate, and so actually, they're the kind of creditors that can't really be frustrated.
So that's why if you give all your possessions away before you die, that's not defrauding your children's legal rights, because they have no legal rights. But you're saying that if you have some sort of will substitute that moves all of your possessions away from your children after you die, then that could be fraud.
Well, to be honest, I wasn't really thinking about children because, but I'm thinking in terms of general creditors.
So you think onerous creditors? Okay, right, okay. Because I was more thinking that, see, to me, I'm not sure that I would describe it as fraudulent because, well, yeah. So if it's a will substitute that takes effect after death, then I could see that could be considered to be something that's although, because a special destination is caught by the creditors, so that's a separate one. I think of another will substitute. So the common property one, let's say if you accept for a minute joint property, that wouldn't. Would you say that was defrauding the creditors if at the moment I died my share went to the other person?
If that was the aim of the... I mean, the thing is that for all...
So the intention has to be avoided.
Yeah, because you're relying on the common law rule, you have to sort of concilium fraudis.
Okay.
And that's a test, I think, that or that will be your route out. You would say, well, actually, I just thought this was a neat way of doing things. I didn't anticipate that my assets would be insufficient to meet my obligations at the end, and therefore it's all fine.
See, that's sort of what I was getting at, because when I was saying there's sort of three classes of creditor, not quite as precise as that, but I was thinking sort of you can have creditors of a variety who may. See, I don't think I owe my future creditors anything, because I don't think I owe them a duty to have assets in the future.
You don't, but if you have taken steps to ensure that you don't have assets, then you commit fraud when you contract the debt. What against Finlay, 1846.
Well, I would need to read the case, but I don't know.
I don't like the cases because of the insolvency effect, but like the Richmond, there's a wheelie cases.
Okay. Well, I hadn't thought about it in those terms. I mean, I suppose that could be the general policy argument that could be the policy rule that I was grasping for when I said, look, if people actually started to do this quite a lot, I suspect the courts would not sit back. Maybe they would fall back on something like that.
I mean, there is, of course, there's a remedies issue then, because you commit fraud when you contract the debt, but if the person that you undertook the will substitute with was not party to that later fraud, then you can't infect their transaction with that later fraud. The only way you'd be able to set the will substitute aside would be to show that together they were part of a fraudulent scheme.
Yes, I think so. I think I'm following you on that.
Yeah, it's a little bit like the old cases on stellionate.
Right, double sales.
But the old cases on stellionate, double sales the other way round. They're not offside goals cases.
Right.
They're cases where somebody sells, completes title, conceals the fact that they have completed title, and then gets a second buyer.
Yeah, sure. Yeah.
Whereas normally it's the conspirator is the first buyer rather than the second buyer, whereas in the normal offside goals case, the conspirator is the second buyer, not first.
Okay. Well, I guess, I suspect, I didn't think about it more, but I suspect you could criticise the ones that are overtly trying to avoid creditors.
Yeah.
You could, I guess, if there is this powerful, I'm not a great expert in the Pollyanna, a common law, but if it is as powerful as this, then yes, I guess you could, yeah. I know you've written about it, but I haven't read it yet. Just getting my defence. But yeah, if it says, no, of course the difficulty I guess would be sort of the difficulty that you have, not in any way particular to this area, just generally with any type of fraud, it's showing that it was actually, it's unlikely to say, I am doing this to get away from my dastardly creditors. Yeah. But then the court has all sorts of ways of looking into that.
Particularly if that's the way it's been marketed.
Well, yeah, indeed. If it's a creditor busting, So is that a particularly strong Scottish rule, would you say?
No, that's just the actual Pollyanna.
Mm-hmm. But do you think the Scottish rule is a sort of strong variant of it? It's just the same.
It's not a particularly. It's not a rule that people have really thought about much for a long time.
Sure.
And it tended to come up in a different context, namely assertion that fraud gave you some sort of preference in insolvency. So it was a way of pulling assets out of insolvency.
Well, I will definitely have a think about that because, as you say, one of, not the only, but one of the big reasons for will substitutes in America is asset protection.
Yeah.
It's not the only one. Of course, they may not have the Act of Pollyanna in anything like the form we have.
Yeah.
Or the equivalent of it.
Yeah. But I suppose also it depends on how broadly you conceive of fraud, because it's quite clear the intentional ones that we've spoken about here, but there's that grey area going from your second to third category of creditor, are they in view, and how broad it is. And the second one is about, the tricky one again is about maybe accessory liability.
Exactly, that's
of the will substitute. How much infection do you need to be allowed? So there's some grey area still there. Ross?
Okay. One historical observation might be pushing us slightly, and one question I'm going to ask, if I may. Historical observation just coming out of that. I'm not sure how relevant it is. Before something like 1868, you had, thinking now of evading legal rights, and you had the law of deathbed, so that which was pretty well purely Scottish, so that you but that was largely heritage. You're doing the final illness transactions, moving the estate away. Apparently, I suspect this is not particularly, it's a bit obscure in case law. I haven't actually gone into case law particularly, I've largely relied on McLaren and the like. But there was an equivalent rule, which you get in, I think, Brampton and the like, there was an equivalent rule for movables as well, which was more restricted. But it was there, and there was a period after 1871 or whatever, when they abolished the law of deathbed, when there was argument, well, actually you didn't abolish it entirely, you only abolished it for written instruments, and therefore it could survive for movables. And I think one of the cases, and again I'm only going on what McLaren quoted, where the court was saying, well, we're faced with, I think it was a cheque written literally on deathbed, and they got around it because it was actually just a pre-existing obligation, in fact. One judge saying, well, if this happened and we had to decide it, well, we start thinking about, is this fraud, is this sham, or whatever. But they never developed that term, and it sort of pretty well died. I suppose it's maybe not practically enforcement, but I just raised that.
No, that's very interesting.
And the other was just a question going back, and I don't know if I was missing a subtlety of yours, or I'm being too subtle in the question, or just, you were talking about donation mortis causa on deposit receipts.
Yes.
And then you mentioned the 2016 Act.
Yes.
And I think what you said was it now makes it very difficult.
Yes.
And I wondered, does it not make it purely impossible, or is there...
Well, I was deliberately trying to be evasive there, because I don't really understand. I don't really understand what that section means. Because it starts off by saying, donation mortis causa is over. And then has a second subsection that says, this does not affect having conditions on gifts. Now, as I read the preparatory materials, they seem to be hinting at the fact they were going to try and allow people to, if they really, 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 really wanted to, and made it very, 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 very clear, they could still have a donation mortis causa. But the idea was to try not to have it almost by default. Exactly, sort of power ballot donation mortis causa. Really go for it. But I don't know, because I mean, it's funny because this very point, because when I wrote this, the 2016 Act was a bit more than a twinkle in the eye, but it hadn't been passed, and I actually said donation mortis causa, endangered species, blah blah blah. But I can't remember if it was the Law Commission or the government notes, or both of them, seemed to say they weren't getting rid of it completely.
Certainly slightly worried.
Yeah. So, but it was a very, very well perceived point of subtlety on your part, Ross. Because I was very careful when I was talking about this to my students to try and be simple in the lectures. Oh yeah, donation mortis causa all over, probably. I don't quite understand. I can't work out from the wording of the statute. It's not. I mean, I'm not saying I'm the greatest expert on all law, but it's not particularly encouraging if I've looked at it for quite a long time. I still don't really know what they mean in the statute. So either they have tried to allow you to maintain this donation mortis causa if you really want to, or they have completely abolished it, and I don't really know what the point of subsection 2 is.
Maybe they hope
maybe
in the next 40 years everybody will think
it's too dodgy, we won't try it. Well, I mean, one of the funny things about donation mortis causa is it went really quiet in Scotland for years and years, but there have been quite a few cases in England recently. There was one that made it into one of the legal periodical, like,
Send against Headley.
could have been that one.
Was that extended it to real property?
Yeah, I think it was that 2015-16 time.
I only remember that because it was in there somewhere and I read it in the film. So,
that's right, because there was a sort of plume of donation mortis causa cases just after we said we're getting rid of them. There was a little run on them in England, and they've the Court of Appeal was quite critical of people sort of using them too much.
Somewhere I read, I think it was just in the library the other day, that Poland actually thought of bringing legislation to invent them, to bring them in.
Right.
They didn't actually, but 3 or 4 years ago, so
It's
your legislation is like abolishing conditus testator, you throw babies out with bathwater.
Well, I wonder if that's what, that's the only thing I can think of. If either they do want to allow people to, but that's mad. Like, we're going to abolish the donation mark, but if you really, really want it, you can have one. So I don't know if they were worried about, but then there's any number of ways you could say, just by using the words donation margis causa does not create a, you could have, if they wanted to sort of clear it up rather than get rid of it, they could have done that. So presumably they do want to completely abolish it, but then I'm not entirely clear what they're doing in section 2.
Maybe they want a referendum on it.
Ross, given we're live to the nation, I don't want to get any hot water. But I think, yeah, I was deliberately evasive there because I don't want to completely go, yeah, they're definitely completely all gone, because I'm not quite sure they are yet. I don't know what other people think. I mean, has anyone else seen this section? It's a bit weird. Yeah, it's a bit weird. It is a bit weird. I mean, if you look at it, I mean, maybe I'm missing something. It's very possible, but it just struck me as just being a little bit odd.
I think we just kind of commented that any gifting made in contemplation of death was now being treated as a straightforward lifetime gift, and
well,
left it there.
And that's what they say in the propriety notes, but they don't actually say that in the statute. They don't even say the presumption from now on will be that they don't say that in the legislation. They say that in the reports, and that's why I was a bit so. But that's what the position is.
But yeah, I mean, I suppose you could see it drawing a distinction between gifts made in contemplation of death and gifts that are made conditional upon your death.
Yeah, yeah.
So maybe they just took the view that it's too great an incursion into personal autonomy to prevent people from subjecting their juridical acts to conditions. That's probably what thinking went.
Well, no, I think. I think people should of course be, but I'm not sure. I guess is that a sort of baby out with the bathwater point then? They were worried people would think, oh well, they've abolished donation margis causa. There's no more conditions on donations.
Well, there's no more. You can't have a condition of your own death.
Yeah.
And you looking from Mars, the Martian might ask, well, why is that the one thing that you're not allowed to make your gift conditional on?
If they figure it out, I'd like to know. Because I don't see what the massive problem with it was, but it's just me.
I've got 3 really quick points.
Oh, goodness, sorry.
There's not anything really. Your probate, avoid probate, like why has there been such enthusiasm for will substitutes in America when there hasn't been such enthusiasm for will substitutes here? That to me seems like a sort of broader example of this American legal cultural enthusiasm for just stopping the state being involved in your property in any way, shape or form at any time at all. So like I run up across that all the time in like expropriation stroke taking state work that I do, where in America it's just that even the basic idea that the state may have anything to do with your property is an affront to their kind of idea of fundamental rights, and that sort of legal cultural principle does not exist in the same way here, I don't think. Not that we love the state interfering with our property rights, but there's much more of a acceptance of the fact that that is always going to happen to some extent here, I think, than there is in America. And I think, like, I think what Dot's saying about the fact that, you know, people's estates are small, people don't bother getting estates confirmed anyway. People in Scotland don't have a lot of money generally, so there's not a lot of needs for it. That will definitely explain it to some extent. But I just wonder whether we just don't have that same essential antagonism to the idea of the state.
It's ideological, I agree.
An ideological aspect to it. So that was one thing I thought. Another thing I thought, when you're talking about these succession contracts and the idea that if you make the older cases where they sort of said, oh, if you make a succession contract but then you do actually go ahead and test, then your testament would be void. I just can't see how that can be right. You're contracting away capacity, effectively, is what we're saying. But you couldn't contract away capacity to marry, for example. And I think that legally they would say, you know, your right to test is in a similar sort of category to your right to marry. Maybe, no, you think it's not as fundamental as that?
Well, it's just that there are greater long-term problems. If you say a marriage is just void, and the people don't realise, and they go ahead and have children and so on, that there are big consequential problems. Whereas those problems don't arise to the same extent if we say, well, we're just not going to allow effects of that.
I wasn't thinking about that. I was more just thinking about the fact that, as a public policy matter, a court would never enforce a contract where you had contracted to not marry. The court would say, as a matter of public policy, that is not that is not something you can contract over.
But I think part of the reasons for that, at least historically, were the consequences of it being void for children.
Although I don't know if that, I feel like that idea of marriage being a right, or your capacity to marry being a right, still follows through today in like human rights.
Yeah, I mean,
but that's got nothing to do with child rearing now, or legitimacy or anything.
For today, that makes sense. But if we're trying to sort of use marriage as an example of understanding how they would have thought about succession, I don't think we can.
Although, I guess this was just like if we're thinking about it today, then I don't think you could
draw the distinction. That's fair.
Yeah, it just seemed wrong.
No, I completely.
No, I can't think what now. Oh yeah, all I was going to ask was, this joint property, this was a question. Is your reading then of the bad case that there are other instances of joint property in Scots law and we just don't know what they are yet? Or that you could just choose to hold anything in joint property and we just didn't know that?
I think, I know. I think that reading, what he actually says is that he says that there's two types, and the way he says it, he seems to suggest that trusts and voluntary association it's not a closed list. That's my reading of what he says. Now, I talk a wee bit about this in the paper and say, you can then go on, and there's a hint that he suggests that you could choose. However, I then also, I think being fair, go on to say, he does say that a husband and wife are not sufficiently close relationship. And that's pretty slam dunk in terms of against it. But I merely raise the fact that I don't think...
Or that, maybe that's...
I don't know, you're a clone, I don't know.
Would it solve stuff with limited partnerships? The problem with limited partners, that technically every time a new partner joins a limited partnership, the entity is reconstituted, and therefore you need to technically say you have new owners every time. Whereas if you said that you had joint ownership, a limited partnership had joint ownership, then when someone left, their little part would just go back in. Does that work? Am I wading into the world of property?
I think the thing is, the problem is not the property, it's the personality. So it's not like you've got owners coming and going with a limited partnership. You have one owner with a limited partnership, but it dies and is regenerated like Doctor Who when a new partner comes in. So it's not people coming and going, it's one person changing.
The English partnership works like that. So the English partnership is all held in the trust. And so as each partner comes and goes, their share comes in and comes out.
And some partnerships do hold the property in trust like that in Scotland, basically for that, to deal with the problem of continuity.
Thank you very much. That was very useful. Everything's been very useful. It's been great. Wish I'd come and done this before I published it. That would have been much more helpful, I have to say.
Great follow-up.
Well, I'm hoping to write something up on it. So
Well, thank you very much.
Do you have a mailing list so I can ask people who've been here?
You can email me and I will make sure that it finds its way.
People.
So, I'd like to thank you in the customary way with a round of applause.
Thank you very much.